Good morning and welcome to the second meeting of the Solicitors in the Supreme Courts of Scotland Amendment Bill Committee. Can I remind all members present, including members at the table, though mine's off, to switch off mobile phones and tablets, or at least it says silent. The first item on our agenda is a decision whether to take item 3, a discussion about the evidence heard today and the committee's approach to the scrutiny of the bill at preliminary stage in private. Do we agree to take the item in private?
Yes.
Item 2. Today we're taking evidence from the promoter of the bill, the Society of Solicitors in the Supreme Courts of Scotland. And I'd like to welcome Douglas Thompson, President of the Society, Sarah Erskine, Vice President of the Society, Donald Skinner-Reid, Treasurer and Collector of the Society. I'll need to find out what a collector is. Robert Shields, Secretary of the Society, and Christine Wilkins, Keeper of the Library, and Gregor Clark, Drafting Advisor to the Society for this bill. So if there's problems with the bill, it all lands on you, Mr Clark. We understand that. That's all right then. Now move on, and I wonder if you want to make any kind of opening statement to us.
Madam Chair, thank you for...
Thank you very much.
Thank you for inviting us to attend and give evidence this morning. The members will have had the opportunity of reading all the papers which you've submitted, will be aware of the history of the Society, and I believe that some of you had the opportunity of visiting our premises recently, so you're familiar with the layout of the premises, and I think the purposes of the bill are set out in full. We're happy to take questions from the members on any matters arising.
Well, thank you very much. So I'll start us off. Is the promoter confident that none of the alternative approaches set out in the promoter's memorandum is more appropriate? Who would like to take that one?
I think
Mr Shields.
Thank you. It's a society of 220 lawyers, and there's always a danger that you end up with 220 different opinions on how best to proceed. But we have taken advice, and I think we did reach agreement that it would be better at present to consider the legislation because the alternatives are essentially, I think, ad hoc or pragmatic, which would be used as the circumstances arose or dictated. What we're anxious to do with this bill, if I may say so, is to lay out specific powers or authorities now that may be used later. And in other words, they're on the statute book to be used later. What?
I was tempted to say oven ready, but I don't think we'll use that expression today, shall we?
No. if required. I mean, the point is, I think, is that it may be that the powers included in this bill, if they became an act, would never be used, because it may be that the society will continue to prosper for years to come. But we're acutely anxious of changes in the legal profession and society in general, and we're anxious that we're not seen in the future to have done nothing. And I think that what this does is set out specific powers for the members to take decisions in 5, 10, 20 years' time. I think it's important that we say that we've not got any pressing problem now that urgently requires something to be done. And the alternatives that were considered are sometimes reactions to difficulties that have arisen. And we don't want that. We wish to be able to, if the society is going to close, for example, we would prefer that it was done in an orderly fashion rather than in urgent actions before the quota session or wherever.
Perhaps just for the record, just to briefly elaborate on the changes that have taken place that have taken you to this point today in front of the committee with a private bill.
I estimated that before the First World War we had about 330 members, and I think we're now down to about 220. It's a voluntary society. People don't, they're not required to join. They join freely. And although the numbers have probably been stable for some years, the demographic membership, the demography of the membership has changed, and that younger people are not joining in numbers that suggest that in 10 or 20 years there will be enough people fit and able to administer the society. The society, as you may know, owns a substantial building, and we have financial assets in support of the Widows Fund, but that all takes administration, which is quite time-consuming. And if we don't have people who are fit and able to do that, then I think the society might drift into serious difficulties.
Which takes me to the serious difficulties, what the implications if this bill isn't passed for the society, if everything, the status quo pertains.
If the bill wasn't passed, then the society would continue as it is just now, but with we think, no power to close it other than perhaps emergency ones before the Court of Session or something along these lines. But with the bill, then at least if the society was to close in 5 or 10 or more years, it could be done in accordance with the statutes, the powers which the statute granted. But there's two aspects to this. One is the society, and the other is the Widows Fund, to be renamed the Dependents Fund. And these two aspects may be dealt with separately. I mean, it may be that we would close or recommend to the membership that the Dependents Fund is closed, and that would ensure the society continues for another 50 or 100 years. But it's very uncertain. It's the break of the habit of people joining these sorts of societies that's the problem here.
Perhaps we'll come to details on the mechanics of these other, closures and changes. My colleagues will come to that. The legal structure of the society, to me, is quite difficult to follow, but could you perhaps explain the relationship between the Articles of Association, the Royal Charter, and the 1871 Act, so that I can understand it?
I think in 1750s, there were lawyers hanging about the Court of Session.
They still do.
But this lot were unruly, and I think...
They still are.
Well, I don't know about that, ma'am. Anyway, in those days, I think there was an act of sederunt or something like that signed in order to get people who were going to appear regularly with counsel to identify themselves, to introduce some sort of regulation, and that was done, I think, in 1754. In 1784, the society was founded as a society, and it's in the history book as to what was involved and how it developed, but it was essentially solicitors supporting counsel because counsel were in court or doing opinion work or whatever. The term clerk is quite deceptive, I think, because clerk sometimes means qualified solicitor as opposed to someone who was just doing clerking in those days, keeping papers. But I think they became sufficiently established, the society became sufficiently established to ensure that it was a cohesive body. And I think by the mid-19th century, they were controlling something like 3/4 of all the business that was going into the Court of Session for counsel. So they had become monopolistic, I think, almost, not quite, but almost. And the Royal Charter, I think, was to produce some sort of cohesion and stability and, I'm afraid to say, respectability. That was fine. But by the 1870s, I think the Scottish legal profession was beginning to become much more cohesive. Then Lord Advocate George Young, later Lord Young, produced several bills through Parliament to establish various societies and to try to regulate the solicitor branch of Scotland. And I think the result was that the members of the SSC Society felt they were sufficiently well appointed, sufficiently dug in, frankly, to be able to get their own legislation to secure their position. The difficulty is that they either never anticipated that it wouldn't be there, or they deliberately didn't put something in the bill to allow the society to close. So they regarded it as something that would continue in perpetuity.
Can you instruct at the Court of Session if you're not an SSC firm?
Yes.
You can. So it wasn't monopolistic in that way that nowadays as WS is as well. So fine.
The legal profession in the 19th century was still not centrally regulated. There was no central body for lawyers in Scotland. But
no law society.
The law society didn't exist until 1949. So each area of Scotland had its own local faculty with its own rules,
Right.
and for the Court of Session, either right to the signet or Solicitors Supreme Court were required to instruct counsel, but that did not apply in the rest of the country.
Right. Thank you very much. I think I understand the purpose of the society. You've really explained that from its genesis. On your management, how are decisions currently made within the society? How does it work? I mean, you're telling me one of the problems is administration, in an ageing population, as it were, to do the administration. How does it actually work, and what powers do the various office bearers have? Well, perhaps start with just office bearers and what you do.
Well, the membership is spread throughout Scotland now, I think. In the past, it used to be concentrated very much in our building and in our round about the Court of Session. But we now have people all over the place, and for that reason, I wouldn't say the society runs itself, but the 3 statutory meetings a year are enough to allow the general administration for a society like this to be dealt with by agreement of the members. And since I have joined, and that was in 1980, I don't recall there ever being any serious dispute that involved a serious vote or fighting amongst members or anything like that. It's just, it just seems to be there and seems to have run like the House of Lords.
Oh, that's a controversial comparison. I was going to ask, though, you do have assets. I mean, business, you have a building, you've got
Yes.
a fund. How is that managed, because there has to be something,
Well,
daily or monthly stuff like that. Yes.
You'd asked what the collector's job was, and the
Yes, I
collector,
did.
the collector's effectively the treasurer of the Widows Fund, and in that capacity, I collect the subscriptions that are due. The 1979 Amendment Act allowed us to invest more widely, and the assets of the Widows Fund are managed effectively by a firm of stockbrokers, and they pay the income to the bank account that I maintain, and twice a year we pay out the widows the annuity that's been agreed. Excuse me. It's the fund. The annuity fund is reviewed every 5 years, and in the 25 years I've held the post, the annuity has increased at each event. But when I started as a collector, there were around 100 widows, and there are now 46. So that's where you see the demographic really changing. So day to day with the Widows Fund can be quiet, or it can involve me at the times when we're paying out the annuities in May and November. A day's work, it can involve that. You need somebody who can write a ledger and operate a bank account. Those are not necessarily things that every lawyer can do. The Treasurer's job is more day to day.
Laugh about that one anyway.
The Treasurer's job is more day to day and does involve considerably more admin. The Widows Fund isn't a hugely busy thing, but the society itself, the Treasurer's job, is busier. I'm liaised with Christine Wilcox, our librarian, really on a daily basis. And I when I was working full time, Christine would post me invoices to settle. These days we tend to use new technology and scan things back and forward, and the bank operates on the basis of, I haven't written a cheque for years. I mean, it's all done in that fashion from home. So again, it's not massive admin there. Managing the leases of the premises is currently an active matter. There are events going on there that we're rent reviews that we're dealing with and various other things. The biggest improvement for me has been technology, because there are 13, currently 12 council members, and although I've become the mouthpiece for a lot of communications with outside parties, I'm only a team player. I'm not leader of the pack, and people tend to come to me asking questions, and I then go to the council by email saying, what do you think, folks, and then reply with the majority's view. So day to day, I would have thought that the council members will receive at least maybe 1 or 2 emails from me a day, maybe less if it's quieter, but generally the council are actively involved in the management of what's going on. The members become involved at the stated general meetings 3 times a year, if there's anything in particular that needs to be more widely discussed.
In terms of the Widows Fund, is the money that goes into that, the contributions from the members, an annual contribution or levy or whatever you call it, is that go into the fund? And what happens to the rent? Does that go into the rent from the head of
No, that you have 2 very distinct things. That you have the society, and it owns the building, and it receives the rents and members' subscriptions. The Widows Fund has a portfolio of investments. It has no interest in the building whatsoever. So it receives its income from the stockbrokers quarterly into its own separate finances. And I produce at the end of each year, at the end of March, annual accounts for each thing. One for the Widows Fund, one for the Society. They are totally separate.
I'll leave more detailed questions. I've got 2 former accountants sitting here, so you're with friends, or maybe not, as the case may be. I'll now pass over to Bill Bowman, one of the former accountants.
I sort of still am an accountant.
Oh, sort of still is. I beg your pardon.
So thank you, Convener. Can I just also say thanks to Robert Shields for showing us around, John Mason and myself and the clerks the other day. It was very interesting to see the building and how it works. Under the general heading of sort of notifications, just a couple of questions on that. In paragraph 4 of the promoter's statement, you say the bill does not include any provision affecting heritable property, but that you will go on to note that you will, as a matter of courtesy, inform the tenants of what you're doing. Did that actually happen?
I wrote to the Faculty of Advocates to say that we intended legislation, but I don't think I did any more than that.
Okay. And did you get a response?
I don't think I did.
You didn't write to the people that are the tenants on the lower part of the...
No, but Donald deals with the company on a regular basis, and I think at the time that I wrote, I never anticipated that we would move quite as quickly as we have done, if I may say so.
If this bill goes through, will it change the legal arrangement between the society and the tenants? I mean, could they use it as a break?
No.
They would just have to accept the position they're under.
It doesn't affect their position vis-a-vis anything. I mean, at the minute, if we chose, we'd be free to sell the building subject to the leases to anyone we wished. And all that would have happened was that their landlord would have changed. I mean, it wouldn't significantly alter their position at all.
It was just that the paragraph that I mentioned goes on, says the tenants will be sent as a matter of courtesy intimation of the bill and the accompanying documents. So you maybe have...
I don't know whether you did or whether you didn't. I don't know.
Still to do. Work in progress.
Yes.
Okay. In paragraph 5 of the statement, you explain that the Society's members were sent a strategic options paper and then an update to that, and a memorandum was sent to council members with a copy of the draft bill and accompanying documents. And then in June 2019, for a statutory meeting in 2 July, the members considered the purpose of the bill and the associated documents. So you had a meeting of the members. How many members attended the meeting?
From memory, about 10 or 12.
Yes, but perhaps 10 or 12, but they were all sent all of the papers.
So 10 or 12 out of
200.
Is that the sort of normal level of attendance?
It's not an unusual number of members to attend the meeting. The meetings take place at 5 p.m. in Parliament House in Edinburgh. Tends to be Edinburgh members that attend. Everybody receives the information by email, but the number that attend in person tends
Do you
to be quite
have
low.
a process of proxy voting?
Not formally, but it may help to understand the demographics of the membership. And the last count I did, assuming I didn't get too lost in my Excel document, there are 82 retired members, 65 public sector or country members, and 44 Edinburgh members. That's the mix.
They're of equal rights? I mean,
Yes, absolutely.
So that, in terms of if you came to winding up, each one
Oh,
would
absolutely.
carry the same. And what are your rules for passing a motion in a meeting? Is it just a simple majority of those attending, or?
I think it's generally taken to be the, as it were, spirit of the discussion and how people view things. I don't recall ever having got to the stage where we had to take a vote. I don't think we've ever.
But on something like this, would you not think you
yes,
might?
Yes, oh yes. If it got to a more serious point where we were going to have a serious decision to be taken that affected either the future of the society or the future of the Widows Fund, or both, then we would consider requiring a vote, or at least a written answer from each member as to what they thought.
More than the 10 that might turn up, because I guess half of the 10 might be here just now.
Absolutely. I mean, one member, the only member who really commented on anything, had indicated that he thought there should be a fixed percentage in relation to any decision on closure of either the fund or the society. And I don't think that's wrong. I think you would want to know that everybody, the majority of the members did actually agree, and it wasn't just the majority of who happened to turn up. Not least because if you operated on the basis of, well, 10 people were there and they all said yes, you might have nearly 200 that were saying no, yes. And that's just going to lead to litigation of some sort. So we're not an organisation that works in that fashion.
I'm not implying you are, but just how these things sometimes might turn out. Other than that meeting, have you had any other sort of feedback from anybody?
I don't think so. I think they're content to allow us to proceed as we're doing just now, because they appreciate that, the members appreciate that the proposed legislation amounts to a set of power or authority for future use. But
how would you get that feeling when only 10 turn up out of 220?
Well, we send out hard copy to the more elderly, perhaps, members who prefer that, and we send out emails, and if they had strong views about their opposition, we would hear from them. There's no doubt about that.
Would you maybe want to put something in the bill on the point that Bill Bowman makes, where there has to be a quorum of members for decisions to be taken? I think we'd have concern. I may share your concerns that, you know, so few people. I see it's been a gentlemanly, and I use the term broadly, with women as well, but it's a gentlemanly way things have proceeded. But you're coming to quite serious issues, perhaps, particularly with winding up. That would be these are heavy duty.
We had considered that. I think one of the chief difficulties is we started discussing these issues 2 years ago.
Yes.
And it's taken 2 years to arrive at today. I'm keen, when I'm looking at the demographic of the society, to not be the only official left sitting at the table at the age of 85 with no ability other than to try to promote another bill to come back to the Parliament to have authority to do what has by that time become blindingly obvious needs to be done. And my concern about building in a fixed percentage into the Act is I'm then left with legislation that tells me this is the only way in which it can be done. And I think our reassurance, perhaps to yourselves and indeed, to be honest, more importantly to our membership,
Yes.
is that we wouldn't go down a route of proposing closure of either the Widows Fund or the Society without a majority of 55% of the membership actually saying. But if that's built into the statute, and I'm sitting up the road at 85 as the only person left at the table, all I'm going to be able to do is resign from office, walk away and leave an organisation that still exists because it's a separate corporate body. It's not me, it's not us collectively as human beings, it's a separate legal entity sitting there with nobody to manage it. And I think building in, it's not, excuse me, the costs of this exercise for the Society are high. They're not ridiculous, but they're high. But it has taken 2 years and an enormous amount of work, I'd have to say, from our Secretary Robert, to get us to this point. I'm not sure at 85 I'll have the energy to come back to say, could we make it, can we change this to being, we've got ability to make the decision ourselves?
I would just say I appreciate what you're saying, that if you don't have some, you can have some form of quorum rules and then have a provision if you don't meet it to go on to something else. But if you have nothing at all, it just doesn't sit so readily with me.
I hear that. The one member who raised it spoke about the Brexit vote as an example, that, you know, should there have been a percentage built into that legislation? And my point is, I'm not really interested in that discussion. I see the point of principle that you're making. My point is, if I'm 85 and the other members of the committee is 85 and that's what's left, and we're left with an act that says you have to have this percentage, it's going to cost us X thousand pounds to come back here again over I don't know how many years to try and get the thing put through again. And I think that's a disadvantage. What we're looking for here is flexibility among a group of people who are capable of coming to a perfectly sensible way forward.
Yes, John.
Yeah, just on this point, I mean, if you often use a percentage as a quorum, so I'm struggling to understand why that would be a problem, even if the membership diminished, as long as you get 10%.
It's not a problem. What I'm saying is, if you've put a fixed percentage in an Act of Parliament, it restricts the ability of the Society to manage itself.
Although if you were down to one member, that one member would be the 10%, so it wouldn't restrict.
Well, I might not be the only member, but I might be the only official.
Well, I think we'll perhaps just chew over that one, having raised it. We can chew over that and consider it as we move on. John, please.
Yes, thanks, Convener. Yeah, just kind of building on what Bill Bowman was asking about, just again about the consultation that's going on. Can I ask, did the members as a whole get to see the draft bill, or did they not get into that level of detail?
Yes, we sent them.
They've all seen the bill?
And the accompanying documents, yes.
As well, that's fair enough. And
they've been referred to the Scottish Parliament website where everything is.
Right. Okay, so that they've been able to see that, that's fair enough. And then what about the beneficiaries? I mean, I understand there's an advertisement in the Scotsman and every public library, or sorry, one public library in every local authority area has a copy. Were the beneficiaries themselves contacted or involved or anything at all?
No, not the annuitants, no.
No.
No, there's no risk to them in any of this.
Other than that it brings in the possibility of, you know, some stage a lump sum instead of...
Yes.
Yes,
yeah.
But it wasn't felt needed to ask them, okay. And now I understand you got an opinion of council and that is private, so that has not been published. Have the members seen the opinion of council?
No, I don't think we sent that out. I can't remember. No, I don't think I sent that out to them, no.
Okay.
But I think I sent in the documents reference to the council having taken the opinion of council.
Right, yes, he'd certainly told us that as well, and subsequently I think the committee has seen the opinion of council. But I take it, is it still your position that you would prefer us either not to quote from it, or
Yes, I think so. Yes.
it should not be published?
Yes.
But we can ask you questions about it.
Yes.
Okay.
The members of the council have all seen the opinion from the advocate, but it wasn't sent out, as I recollect, to the general membership.
Right, well, fair enough. I'll come back later, but that's fine just now.
I'm going to come back to Mr Skinner-Reid, my collector, just to ask number of beneficiaries currently. I think we have it actually somewhere, but to put it on the record, 46. And how many members have partners and children who could potentially, I know this might be quite difficult, call on the fund in the future at this moment?
Off the top of my head, I think the answer is 203.
Can I ask how much is in the fund?
This week, the valuation was around 11 million.
Oof. And can I then, and presumably do, you say, it's interesting, you said every 5 years it's reviewed. That's a lot of money in there, isn't it? Wish I knew where they were investing. But how do you review it then, the amounts? It's 3,000, isn't it, per payment at the moment?
The Act requires an actuarial valuation, and we worked for a number of years with, I think the company was called William Mercer, and we then moved to a firm in Glasgow, whose name I can't immediately remember, but they have merged with another business, Andy Thompson it was, that was the actuary. And fundamentally I write out to all the members saying it's time for the 5-yearly review. Have you married? Have you divorced? Have you got any more children? People forget to tell you these things. And they fill out a form and it comes back to me, and I fill out a spreadsheet and I send it to the actuary. They then prepare a report based on the information that I've provided from the members, and they'll come back then with a range of recommendations where we could increase the annuity, where we can increase the contributions that people make, and they revise the calculation. Every member has the ability to redeem the rates, a bit like the way in which you used to redeem your few duty. There's a set table that says if you're 65 years old, if you pay this amount of money, £300 or whatever, you no longer need to continue paying into the Widows Fund itself. And that's how it's done. The report comes back to the council, and the council makes a decision on whether to increase the annuity.
I got a wee bit lost there. I'm looking at Bill Bowman, our current accountant, to explain to me. I thought the membership fees had nothing to do with the Widows Fund.
There are 2 fees paid each year.
Ah, right. So
if you're a practising member in Edinburgh, you pay £165 to the society.
Right.
And you pay £35 to the Widows Fund.
Ah, right.
There are 2 payments.
So that's clarified for me, because I thought it was simply on the,
No.
The shareholding returns.
No.
The
members, I think the members' contributions raise about £6,000 a year to the Widows Fund.
That's very helpful. Have you taken legal advice as to the legal duties of trustees if and when you were to close the fund?
Well, the society holds these assets in trust. I think the basic difficulty is it's not a trust that you would necessarily recognise. Yeah. It's not a trust deed in the way that people would think of trustees acting. We hold the assets in trust, and the society does, not the individual members. So the society has obligations exercised through the council and the office bearers in relation to the management of the fund. That's basically how it works.
So beyond the provisions, specific provisions in the bill, what other duties, legal duties, general duties do these trustees have in this sort of unusual trust that isn't registered with Oscar, I take it? So
No. Well, I suppose it's the duties you would have as a trustee. It's not your money. You're looking after it for other people. So your obligation is to make sure that there is a balance between providing the income requirement that the fund has to fund annuities and to secure the capital. When I was appointed, one of the then stockbroker came up with a whizzo idea of investing half the fund in Japan. And my only response was that the only thing I know about the Japanese stock market is you don't invest for dividend because they don't pay any. You're only investing for capital. And I was trying to manage a fund that paid out annuities, and therefore it needed to actually be raising some income. So we dismissed their services. So you are operating, you're looking after other people's money.
Yeah.
That's what you're doing. But it's not a trust in the sense that, I don't know, your granny leaves her estate in trust for her third husband and it's going to move on to other family after that. That's a very easily understood trust. This is slightly different.
I turn to my professional acquaintance here, yes.
A couple of things. First, so, I mean, how is the money in the fund protected in terms of if you, excuse me, if you wanted to build a new building, could you just take that money?
No.
You don't have
It's separate. It's
I know it's in a different account, but
fund. No, it's the widow's fund. It's not available to the society.
And the independent trustees are the ones who would control.
And we are the society holds it in trust.
So there are not what I'd call professional trustees like a bank or
No.
people, right? So it's the people here.
Yes.
Okay. And then you said you write to beneficiaries to ask if they've children or
To contributors.
contributors, sorry. So is the right of the recipient of the annuity determined by the contributor saying that person is entitled to it? Or are they entitled because they are a child, let's say?
Well, I've only in 25 years had 2 children as beneficiaries of the annuity. Their father had died and their mother remarried reasonably quickly thereafter. And that meant that she was no longer the widow and the children then took the annuity. So I ask about what children people have because we could have beneficiaries who are under 21. The fact of entitlement is that the member has died and they produced the death certificate and the marriage certificate and that the couple weren't divorced. It is as simple as a fact of were you married or were you not.
But that's the present situation,
Yes.
but the new situation would be different.
It could be because if it brings in cohabitants as a possibility, the mechanics of that we have not fully worked out because it's an area where, frankly, I think the law is continuing to devolve. The Vice President did professionally a lot of work around cohabitation and family law, and certainly would be somebody who would be very useful in giving us an input as to how we could identify that. At the moment, it's a marriage certificate that
Well, that's what we understood
deals with
in
the
legal
issue.
children. You could have now asking
Yeah.
questions of, do you have other children or do you have
Yes.
other partners? How are you going to deal with that then?
I think that what we're going to have to do, I mean, I can think of one member who died who was still married but was living with somebody. And the answer to that question was, well, the widow receives the annuity. I think it could open up the fund to claims by cohabitants, and I think that you might be having to look at a claim under section, Sarah, help me out here, 28, 29?
I'm sorry, I'm not able to tell you exactly, but I could look.
But
and
one,
come back.
there's an act under the Family Law Act 2006, which brings in cohabitees claims, and there are claims on death for cohabitees, and I think that one might have to look at some sort of decision from the court as to what entitlement the cohabitee might have. The annuity would be part of the assets of the deceased who has died in those circumstances intestate. So it could be that there's something there that we would have to look at.
Your actuaries would want to know this,
Yeah, they
presumably,
would.
if they're valuing the
yeah,
fund.
they would.
And it's a new scenario for them.
Yeah.
So that
I don't ask about cohabitants at the minute because I don't need to. But it's another column on an Excel spreadsheet. Do you have a cohabitee?
Can I?
Sure.
Fine. Can I just return to winding up this fund? It doesn't seem to me that in section 51A5C it says only members will be notified. It doesn't say about notifying beneficiaries.
I don't know.
At the bottom, all members of the society being notified in writing or by electronic means of the stated general meeting convened to consider the recommendation being that the dependence fund be closed. Now, I know you say that, you know, the society by resolution, where is the bit about they get, you know, a lump sum, 51A3, but that's post or when the closure decision has already been made. So, do you think it would be appropriate to notify, you know, beneficiaries that this is going to come to an end, and thereafter that the options will be that they may well have, you know,
I think you would have to. I think you would
lump sum.
have to notify them because you're going to have to get acceptance and agreement that they're willing to accept what the actuarial calculation would produce.
So by implication, you're saying?
Yeah, I think it would. I think you would have to. Yeah, you would need to know that you had agreement.
It says, if the fund is closed under that, any person who is an annuitant at or who, but for that closure, would have become an annuitant after the day closure, shall be offered such lump sum if the fund is closed. Does that cover that? Has it not already happened? Section 51A, subsection 3.
I don't think it's going to happen in a hurry. I think that's my point. The previous actuaries, I'm thinking back possibly 15 years, came up with a suggestion along these lines, and my response was, well, we don't actually have power to do any of that. The current actuary would have a view on it and how it can be accomplished, and it is going to fundamentally depend on computations and calculations that they come up with based on information that I will then have to go and get. This is going to be a process that takes, I would have thought, at least 2 years. It's not going to happen.
Complex, because
it is quite complex.
It's some people coming on stream to be.
Yes. You have in my previous incarnation almost what were referred to as shadow life rents. You've got people hovering around on the edge of the seance table who have an interest in this, but they only have an interest in this through the member. That, you know,
I love your metaphors.
They don't have an interest otherwise. They're out here.
Yeah.
You know, if one was to consult every potential annuitant, well, if you've got people of childbearing years, how long? Who do we keep consulting? There has to be a point where you go, well, these
Obviously,
are the
you'll have a
actual
cut-off
people.
date at some point.
These are the actual people.
Yeah. Can you explain then why this 11 million? Let's say you were closing it. You were able to close this fund tomorrow, and you paid off. You know, I don't mean that in a bad way. You gave lump sums to the claimants, you know, who are existing. And at that date, at the cut-off date, what's going to happen to the rest of the money? Why should it go back to the society? Should it not belong to the people who were the claimants? Should it not? Was after all, it was that fund?
Well, this fund has been built up over the best part of 2 centuries, and originally, if my recollection is right, it wasn't separate from the society. Where is it going to go? Back to assist the society continue existing would be my argument. I can't see where else its natural home would be. I think that the surplus that might be left might be considerably smaller than one imagines. £11 million sounds like a lot of money among 46 people, but it's not among 46 people. It's potentially among 246 people. And when you look at the ages of the members and the annuitants. We had one annuitant died recently who'd been in receipt of the annuity for around the best part of 40 years. So, you know, it's the calculations of these lump sums may well be quite considerable.
Can I just ask the other way around? If there was a deficit on the fund, is the society
It's
obliged to make it up?
No, not that I can see, no. And it's not a pension fund. We had a discussion of that topic some time ago. This is not a pension, it's an annuity. It's an annuity fund provided by me for my husband if I could die first. It's not
So
a
it
pension.
can only pay out what it's got,
Yeah.
in that sense.
Yep.
That's fine. John?
Okay, thanks very much again, convener. Looking at the bill, and I think particularly around 52B, the bill requires a resolution to wind up the society, but not for deciding in the arrangements on how to achieve this. And I think I'm struggling to understand exactly, it's subsection 5, I think, it talks about whether or not such arrangements have been made. But if no arrangements have been made, in B it says must implement that decision in such manner as it considers expedient. That's the council. Can you just maybe explain some of that to me and the thinking behind that as to the society could wind itself up in such manner as it considers expedient?
We have, say, 200 members, but at a council meeting we have 4 or 5 members of council, and at the members' meeting later the same day we might have 10 or 12. The society has somehow or other survived over 200 years because of very light management. Everybody has the same ultimate aim, which is being solicitors in the Supreme Court, and the powers varied from time to time. But I can't honestly say, from what I know of it, that there have been any power meetings at which major decisions have split the membership. It's just, it has evolved and survived and continues to by very light management. And there's a real danger with the demographic imbalance that we end up with very few practicing or members who are involved. I do recall about 2 years ago we had a member who died in East Africa. He'd been in the Second World War in the services, come out, qualified as a solicitor, joined the SSC Society, and in 1950 or 51, I think, went to East Africa. Nobody'd seen him since. Nobody, I mean, he paid his money every year, and we were sad to hear of his death a few years ago, but his participation in the society has been minimal. And I think, looking at some of the old books before the Second World War and so on, you do find from time to time SSCs turning up in Vancouver and Brisbane, and they've qualified, they're members of the society, they've gone on to other things. So that there's a real risk with this tradition of light management and a declining membership, that there's not very many people left to wind the society up and to take the decisions. You have to have people there if you want to have large percentages, but there may actually, in a few years' time, only be a couple of dozen people who have the time or the inclination to get involved.
I mean, I do understand that, and I do appreciate the fact that it's been run on a kind of light touch basis, and that has worked, and largely you've been just continuing to do the same things or very similar things to what you've done in the past. You know, I think as myself and maybe others in the committee, we're just trying to, you know, think of the worst case scenario in a sense, and if it became clear that there was going to be a winding up, and there's quite a lot of money involved, that can sadly be the touch paper or whatever to create tensions and all the rest of it. So I think, you know, I think we're hoping, as you've said, you don't want to come back with another piece of legislation in a few years' time.
Yes.
You know, I think that would also be the desire of the Parliament and this committee. So I suppose, you know, while hoping that the light touch management would continue, you know, we're trying to think of what happens if it doesn't work that kind of way. But I take your point that you don't want to have more detail on that particular point. That would then take me on to the next point, which is that there are details in here about the disposal of any extra funds in the Dependents Fund, or the Widows Fund as it has been, which would come back into the main society. But there's no equivalent provisions for what would happen to the disposal of the assets of the society should the society be wound up. And I just wonder if that's something that needs to be in the bill.
That's a matter for the members then, isn't it?
I think it's a matter for the members as to what would happen at that stage. One of our very well-known members, who may still be known to some of you as committee members, was the late John Gray. John was president of the Society back in the 1980s and a very well-kent face in Edinburgh. I can hear John sitting on my shoulder saying that, well, it might well be his argument, and a group that would support him would suggest that on a final winding up, a lot of the money went to charity. But I think these are private assets, essentially, and it's for the membership at that time. One of the problems that one used to find from time to time in the work that I did, where you were winding up an estate where a will made specific reference to a specific charity that no longer existed, was what were you going to do with that? And I'm probably out of date, but there used to be a C-Press scheme that you went to go to session saying, well, this charity's kind of like the other one, can we give it to them instead? But I think fundamentally these are private assets, and it would be for the members to decide what to do. But I can certainly think, I can hear John on my shoulder suggesting that there might be charities as recipients at the end of the day, but I mean, who knows? I may be dead by then.
Right. Okay.
You're such a cheery person. You're I'm very old. I might be dead. Oh,
Can I ask, when you took Council's opinion, did Council have an opinion on this point as to whether there should be more detail in the legislation?
No.
Right. I mean, I suppose, again, I'm trying to be devil's advocate or whatever here, but I mean, you've suggested one scenario, which is that it would be proposed to the members that any remaining assets be given to charity. So that's one option. Presumably another option is that the remaining members at that point split the money up amongst themselves. And I don't know if there's a scenario that if other solicitors became aware that there was going to be a lump sum appearing round the corner, that they suddenly all start joining the society. And
If there was a sudden influx of members, there'd be no need to close it. It's as simple as that.
okay,
That, you know, the demographic following the crash of 2008, you've had generations of law graduates pumped out of the universities who haven't got jobs. The last firm I was involved in as a business partner, there were very few people working there. I'm talking about all staff under the age of 30. And there is a big gap in the demographic of lawyers, but there's loads of people at my end of the table and not so many further down. If we had loads more members, the issue of closing wouldn't arise.
okay, well, that's fair enough.
If I can just continue John Mason's line of devil's advocacy just for a moment. If we look at the scenario for which you are wanting to have this legislation, which is your concern about dwindling membership and the society finding itself in a position where essentially it's unsustainable to continue and therefore needs to wind up, do you not need to specify some of these things? Because we are talking about, albeit even if it is divided by a number of members, several thousands of pounds as a likely minimum. If you don't specify how those decisions are going to be made and in what interest, and especially given there is, at the very least, without it being specified on the face of the bill, an argument that could be made about who has interests because of the both being beneficiaries and they're being members of the society, would it not be better to, not necessarily in detail, but at a high level, specify what would have to happen in terms of, you know, what the contents of such a resolution at such a meeting of the society do, and indeed precisely what criteria would have to be met at that meeting, such as a quorum, which I don't believe is specified.
I don't know is a straightforward answer. I mean, I think binding the hands of an organisation as to what's precisely going to happen in 20 or 30 years' time is complex and fraught with some difficulty.
With numbers are falling.
Indeed, but with respect, I don't think any of us are discussing binding or even specifying in advance, but literally just saying what categories of decision would need to be made in order for that decision to wind up to be valid, such as, you know, provisions being made, or at least just requiring it to specify how. It's not saying that the provisions for how it would be wound up be put on the bill, but simply that such a meeting would have to state how such a winding up would take place. I'm just wondering what would be the disadvantage of, at that very high level, saying what the aspects or the dimensions of that decision or that resolution of such a meeting would be.
Well, I kind of think that maybe it's already there, and it says 52B3, the procedure by which a decision to wind up the society is to be taken may be determined by the society, A, at a stated general meeting other than the special general meeting referred to in subsection 2, or by means of a bylaw. So we will have to sit down and concentrate on that in the circumstances that arise at that time, if that time arrives.
David, Daniel, your promoter's memorandum states that it is envisaged a decision to wind up the society. Excuse me, it must be catching. Frogs are moving about throats. Would require to be unanimous or nearly so, but that's not in the bill.
But that could be something that was put in a bylaw, which is made under the 1871 Act.
And that escaped me. I hadn't realised that. Well, so how do members know? Let's just continue devil's advocate that they have security in knowing that you're going to use this. The procedure could be or at a bylaw. So you don't have to do it in a bylaw. So it's a stated general meeting other than a special general meeting. We don't have quorums. And or, so it's alternatives. It's not must.
Facility.
I beg your pardon?
It's a facility.
I know it's a facility, but I'm just saying that it could be a biggie. It could be a big thing to do this. You know, a large piece of heritable property in a prime position worth quite a lot of money, notwithstanding there might be tenants in there. It's still worth a lot. And it's just really it's in a sense protect yourself as a society. You're good people. I don't think you're going to do anything, you know, underhanded, but you never know what's going to happen in the future. And so you have to future-proof this, I think, and look at, well, when it's a big thing about winding this up, there may be substantial assets involved. How do you make sure that there's no jiggery-pokery? I love these technical terms. You know, if you had something like at a general meeting, other than a special meeting you've heard, and, or whatever, I can't put in and by means of a bylaw, but you strengthened it so that, you know, there is genuine, this business genuinely unanimous or nearly, so it's a clear will of the membership to give to charity or half to charity, half to whatever.
I can't really answer your question.
I know I didn't like that look. I didn't know what it meant. So, does that mean I'm wrong? We should be pursuing this, or what?
I don't understand there to have been in the recent or distant past any huge divergence of views between the members. We are all solicitors and we're all qualified in Scotland and we're all a member voluntarily of this society, and there's been a great deal of unanimity of thought over the years. It may be, as you say, that dividing up assets brings out the worst in people.
It does.
But there would be suitable resistance elsewhere in the society, I'm sure, if any faction tried to take over. But I'm not aware of any factions or groups or any sort of counter-revolution there. I mean,
surely the process that we've described to you of our meetings, which is that everything that we intend to discuss at a meeting, all matters that we have in mind, particularly about how we're going to dispose of a building, if that is going to come up, is circulated to lawyers. They're
Is
all
it
lawyers.
5 o'clock in Edinburgh, is it not?
It's 5 o'clock in Edinburgh, but we have, for instance, training meetings in Edinburgh at 5 o'clock, which lawyers get to from all parts of the country. If it were such an important meeting where the Society was thinking about disposing of either its Widows' Fund or its buildings in a way that prejudices that particular member who receives the papers either by mail or email, they would get there. They're lawyers, they're members. What we're worried about is that we need the powers in circumstances where we're all getting older. And
I understand that, but it's just in the memorandum you say would require to be unanimous or nearly so, but that seems to get lost into translation into the bill. You know, I'm not trying to be difficult with you. It's like making legislation. As you know, at legislation, you need to future-proof as much as you can. You can't totally do it, but as much as possible.
With all respect, and I'm sure you know that this is exactly what we're trying to do.
I know.
But as far as process is concerned, I detect a concern that our meetings are small and people aren't attending. But I think that's because they get the papers and there's a trust that decisions that are being made by the members that are there follow the views of the person receiving the paperwork for that meeting. If paperwork arrives which shows something that or indicates that that meeting is to deal with a very particular issue that is very close to that member's heart, they would be there, even if it's 5 o'clock.
I understand also, and I understand the complete faith in you know, I'm not challenging that, but my point is, if it says that in the promoter's memorandum, why was it not put in the bill? You know that a decision to wind up should be required to be unanimous or neither, so I'm just curious why it's not there.
In subsection 4, without prejudice to the generality of subsection 3, a determination under that subsection may include a provision as to the voting threshold required.
Section
52B4.
I've turned to you. Right, sorry, here we are.
So they can't have a meeting, they can set a threshold.
Do you want to come in here, Nessa? Are you bothered about this?
I wanted maybe just to follow up and slightly related, because in terms of the membership, you've got a new section that's want to create new forms of membership, corporate, trainee and associate membership, and also to another section allowing resignation unconnected to any disciplinary matters or retirement. You're talking about the membership and how it interacts just now, but then if you're going to bring in new different types of membership, do you not have to define a little bit more the rights and the powers of the existing membership?
Does section 52A, subsection 3, not cover the restricted membership categories that does not, because it expressly states that membership does not include an entitlement to participate in the Independence Fund or to use the title SSC. So these members would have a different status to the full members of the society, and therefore their voting rights and rights within the society would be different to those of full paid members. So there is already that difference in the bill.
Yeah.
But does that not actually get a little bit to the heart of what we're circling around here? I mean, I think the concern is not so much about the size of your meetings or when they take place, or how they are conducted. It's more, I think, a concern that in terms of the provisions for winding up, without any form of specificity of how or for what purposes that decision might take, that there are circumstances in which that decision could be disputed. And I think in particular, if you're creating new categories of membership, that almost provides more grounds for that to be disputed. And all we are seeking to do is, I think, consider whether or not there are things that could be done to minimise those possibilities of dispute, so that there is clarity that whatever decision is made, if this decision is ever made, is that it is sort of beyond dispute, because there is clarity about how and for what purposes that decision has been made, because it's on the face of the bill.
Although these sections sit next to each other, they actually represent different strategic options, because the power to create new forms of membership is for the short term. We're trying to increase membership by or trying to have more people move about the library and use the facilities by creating this ad hoc or temporary sort of membership. The other section that follows, power to wind up, is in the medium, and perhaps not even medium, the long term. And so these, although it's 52A and B, these are actually temporally hugely different authorities.
So let me give you a scenario. So you're talking about the decision to wind up, absolutely medium to long term,
yes.
Membership short term, but if you change the makeup of the society, because you've got these new members, it's quite conceivable you could have a very, very small number of full members and
yes.
a large number of these new members, and then a decision is made by those small number of members who, frankly, at that point, would really no longer be the body of the society, and the associate members, I would have thought, might have something to say about that.
But the new forms of membership to be created and distinct from full membership are not anticipated to be membership forever. I mean, a trainee membership by definition is a trainee who will in fullness of time become a qualified lawyer and not be a trainee. An associate membership maybe for 2 or 3 years. We don't, when you join the SSC Society, it's anticipated that you're choosing to join the society for as long as you're a solicitor. The only suggestion I might say about your is the corporate membership. You might have something there if there was a substantial corporate membership, but the council and the members at the statutory meetings could easily discuss this and adjust it. If it looked as if there was a wedge of people coming in who are threatening the stability of the organisation or the integrity of the organisation for full members, then there would be a reaction there.
What do you get if you become a corporate member? Is it just accessing the library? I don't mean just in a trivial fashion, but is it accessing the library, that's it? You can't use the term SSC?
We haven't developed it because we haven't got the power yet.
What's your thoughts, though, about what were you looking for from corporate membership?
I think sometimes the large firms look for assistance from the keeper of the library,
okay.
And it may be that corporate membership would be additional assistance by way of library research and something like that.
Just to clarify, I can see that, because you're not actually becoming SSC, and a trainee I can perfectly understand. Yes. Associate, what would would that be similar to being a corporate member?
Had a few overseas students and lawyers qualified in other jurisdictions wanting to be able to use the library facilities, and that they can't get access anywhere else.
I think that's the point of the membership of the society. It isn't that we own property, came as a surprise to me after my membership, and it isn't the Widows Fund, because when you're younger you don't think of that, and you don't think that, in fact, that's the important thing. What you're doing is joining a very good library.
No, I understand that. It's understand that. It was just clarified what these be. And I do appreciate that why there's a distinction at the winding up, it would be the SSC members that take the view. Anybody want to pursue anything else along that?
Can I ask a question about explain why you want to give the ability to resign other than retiring or being disciplined out?
There appears not to be a power to resign now. I think once you joined, that was you forever. People drifted away and sometimes said that they weren't going to be a member anymore, but I don't think within the 1871 Act there's anything
It
that
didn't
says,
feel clear enough.
no.
Hey, you're still a member.
Well, you kind of drift away, you know.
If you fail to pay for 2 years, I think your membership ceases automatically. But it's a rather unwieldy process where you have a number of members who exist only in theory, but not in the real world.
And can I just ask, you want to abolish the terms or the offices of librarian and fiscal. Well, why do you want to do that?
The 1871 Act originally had powers to discipline members because there was then no Law Society of Scotland, and there was a fiscal, or like a procurator fiscal, who presented the prosecution case at any disciplinary hearing. That doesn't apply now because we have Law Society of Scotland, Scottish Legal Complaints Commission and various people like that. So we don't need a fiscal. The other thing is that the keeper of the library kept the books in order, but wasn't necessarily a qualified librarian. But since 1871, the profession of librarian has risen and fallen like everything else. But we still have qualified librarians, and we do have now. The librarian to the society is a title given to a solicitor who has no training in librarianship. So we simply want to adjust the terminology to meet things that have changed since 1871, frankly.
So you can still have a librarian, but not in such a formal way.
Well, a librarian need not be a qualified lawyer anymore.
I wanted to ask about the current provisions for, if I use the old-fashioned, widows and orphans. So you say 3,000 is paid to claimants. Is it 3,000 to the widow and 3,000 to each of the children, or 3,000?
No, the children only come in if there isn't a widower or surviving civil partner. They take precedence. The children would only come in if there isn't then a widower or surviving.
Right, now let's look at then if there's children. I take the situation where mum and dad are both dead, so we've got the children. What age is the cut-off currently for receiving it? And is it per child? So 21, and that's per child. 3,000 per child.
I split it between the two daughters who were involved, one annuity for that member who had passed away, and the children shared it.
So 1,500.
When one of them hit 21, her sister then got the whole lot.
Will that continue when there's changes? And I'm kind of asking a daft question, because I was thinking about the fact that I think parents have an opportunity here when parents, I think, have a duty or can be called upon to contribute towards a child up to the age of, is it 24 or 25 if they're in full-time education? There's something lurking in me there that says it, that this is an opportunity perhaps to extend the payment and redefine what you're doing up to 21 in those circumstances, whether it's college or university, for residential charges.
That's a rule of element, I think.
Sorry?
That's a rule of element in family law, and it's very specific about a child being able to claim aliment from a parent. But I don't think that applies necessarily to what's happening here.
I'm just asking if it would be an opportunity to put that. I mean, you're refreshing with regard to who are children of the deceased. You're refreshing other things. So it seems to me there's an opportunity there to think about that, where, at least they don't pay tuition fees, but they've still got other costs, and they would have a claim on the parent. Whether that parent, one parent still survives, maybe you bump up the amount there from the 3,000 to that parent, or if both parents are gone?
In part, that comes down to the actuarial advice.
Okay.
Yes, the fund's got a lot of money in it, but it's been built up over 2 centuries.
Yeah.
The individual contributors are not paying a huge amount of money annually. And I think my thinking has been around the lines of you're getting quite a good, well, you'll be dead, but you're getting quite a good deal for your family for a modest contribution.
Yeah, okay.
If we were going to go down the route of widening all of that and increasing the payments to, let's say, 4 children, then I think you might be having to look at a different contribution from members based on the number of kids that they had or whatever. That's starting to become considerably more complicated, I think, than an annuity fund.
No, it was just a fleeting thought.
No, I'm not disputing. I can see where you're coming from. I'm just saying I think it would have quite a number of knock-on ramifications in relation to the fund overall.
It was just a fleeting thought. And it's floated off now, as far as I'm concerned. John?
Last one.
Yeah.
Just a relatively minor point. In section 1, subsection 6, you're changing the title from Widows Fund to Dependents Fund, and again in subsection 10. I understand in the 1871 Act, the title of section 34 still says Widows Fund, and I just wondered if that needed to be changed as well.
Right.
I mean, maybe that's something we could come back to. The witnesses could come back to us if they want.
I think it's probably been missed, and we'll certainly look at that and attend to it.
That's great. Thanks very much.
I don't think we have any further questions. Is there anything you would wish to add? Anything we've missed or we've misunderstood, or any other more interesting metaphors from the collector?
I think I would say that we're grateful for your attention to this and for the care that you've given to looking into this. But I would stress the point that we started with, which is that this is not an immediate problem in the sense that we're panicking. We're actually looking to 10, maybe 20, maybe 35, 40 years from now, I don't know. But it's to do with the demography of the society in which we find ourselves.
I thank you, and I think we do appreciate that and the changing environment. Well, I thank you very much for your evidence, and that concludes this session. I briefly suspend the meeting to allow the witnesses and any others to leave, because we've now voted to go into private session after this. Thank you very much.